Hello and welcome to the Echo Chamber podcast. My name is Tony Groves, and today I'm 1/3 of what is something that we've been looking forward to for quite a while, I'd say. Remember folks, the Echo Chamber podcast is a free-flowing conversation that may occasionally touch on mature subjects. As always, I'm joined by my co-host, Martin McMahon. How are you, Martin? Do you ever go home?
I was just going to say, you're only pretending that I went home, Tony. I sleep outside in the car, come back in here, I do a pod, back out to the car again.
I'm sick of the sight of you. More importantly, we're delighted to be joined in the Tortoise Shack by solicitor at McGarr Solicitors, director at of Data Compliance Europe, blogger at tuppensworth.ie, and Twitter pot stirrer Simon McGarr. Simon, thanks very much for coming onto the podcast.
Hello. That's a long and undistinguished CV that you've lined up, but nonetheless I'll own it.
We had to take out the inflammatory or defamatory stuff. No, thanks so much for coming in. It's needless to say, I'm delighted. Martin's very excited.
Yeah, we get some guests in here that just tick the boxes for me. You're one of them, I have to say. You tick my boxes on what you do with data protection. I think it's great stuff. I want to jump straight in. Data. Give us a rough of what data is and why is it so important?
Well, let's imagine there are two general classifications of data in the world. One of them is the kind of data where you count things. So if you imagine that there is actually a whole stream of data which runs and is shared globally between the EU and the US and other sources, where we count how many times the blades of windmills go around.
Okay.
And it's useful because we know what the energy generation that your energy generating windmills have. And it spins around and goes click, 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 and all those numbers travel around the world. And literally nobody cares. I mean, it's useful for its thing, but it doesn't have any impact on anybody's personal existence. Nobody minds. That's non-personal data. And then there's the other kind of data which is about human beings, and that's personal data. And that's data which relates to a person. Now, handily, there was a Irish case went to the European Court of Justice, and it got a judgment just before Christmas there. So the Court of Justice has a nice, fresh definition of what personal data is. And basically, it's data relating to humans.
Okay.
Relating to. So it's not just like your name and address.
Yeah,
but if I describe you without putting your name beside it, that's relating to you. If you even write an essay, which is what the case was about, if you write answers in an exam, the question was, well, are the exam answers that you give personal data? And the court said, yes, they are. They're personal data because they are a measure of your intellectual and creative and knowledge base at that time. And therefore, they're about you. They certainly tell us things about you.
Yeah.
And do they have a major impact on your life? They do. Because the personal data that you've created in an exam decides whether you passed or failed, whether you, in that case, Mr. Nowak, whether you get a qualification as an accountant or not, and whether you can proceed into a profession or not. I mean, you could hardly think of something that is more intimately related to you. And that had gone all the way through the Irish court system, and the reference was made at the Supreme Court level. The Data Protection Commissioner had received the complaint from Mr. Nowak originally, who said this is personal data, and it had been rejected just like Max Schrems's complaint had been rejected as being frivolous and vexatious.
Yeah.
So we now have a new definition EU-wide because the court didn't feel it was frivolous and vexatious. And the court was perfectly happy to give a decision in favour of Mr. Nowak, as it turned out. But helpfully for lawyers and other people who are looking for a nice snappy definition, there's also a nice snappy definition now from the Court of Justice, which is the determining court for these matters for all of Europe, about what is personal data. So when you say what is personal data, it's not an abstract question where I give you what I think. We can actually go and look it up.
We have a legal definition, and and you know it's because everybody thinks of the data now. Everybody automatically goes, in the new world, Google, Facebook, these people who are I get into my phone on a Saturday morning. And the car get into the car on a Saturday morning, and the car tells me how long it's going to take me to get to the girls' ballet class because it knows on Saturday morning that's where Daddy's driving to. It's a learned behaviour from the phone to GPS. It all knows what you're doing. It's tracking you.
It doesn't know just what you're doing, because in order to tell you how long it's going to drive there, it knows what all the other Android phone users are doing as well, and it measures the density of traffic on the road by the speed that all those cars and phones are travelling. So it's a very valuable pool of data when used anonymously like that. But when you actually examine it, it's based on enormous quantities of what must be personal data, because it says where this person was at this time.
I sort of think of personal data in my own personal experience is what can be used against me, what information can be, and I don't mean just by authorities, I mean by if it fell into the wrong hands, can this be used against me?
Yeah.
And I take ownership of my own data, very much take ownership of my own data.
Well, I'm in favour of thinking of it as this. If you are in control of your own data, that is to say the data relating to you, your personal data, then you are the author of your own life. What are the things that you present to the world?
Yep.
What are the things that you wish to reveal and not reveal? And that should be different depending on who you're meeting. After all, we all present different facets to ourselves when we're at work, when we're with our family, when we're out doing things in hobbies and so on. And all of those different facets, we should have the power to be able to present those as appropriate. Without that, we have what's known as context collapse, where you lose the context of who you are in different circumstances when the two are brought together. Mm-hmm. So I say that if you have personal data in the way that the EU law has described it, if you have control of your personal data, which is not to say you have sole ownership, and it's balanced with the public good, but if you do have that kind of level of control that the EU envisages for individuals as a human right, you are the author of your own life.
Mm-hmm. I agree there.
I think that's really why it's interesting. It's also why it's important. Okay, it's probably more important that it is interesting, but it's still there. It's still there. It is relevant to people, and really, when people see the value of it, is the moment when it appears that they have lost control of their own life, when they're no longer their own author, and that's a very distressing experience.
And this brings us straight into all data leaks eventually.
I think so. I think all data leaks eventually being a time scale of forever.
Yes.
If you decide you're going to keep a data store, and you say, we're going to keep this data store and we're always going to have it. And this was something that I found most alarming when the Department of Education was setting up what was known as the Primary Online Database, the POD. And their initial intention was to store information gathered about 5-year-olds permanently. They said they would review, not delete, but just review the data as to whether they would store it permanently when the person reached the age of 35.
My God.
But the intention was to store it indefinitely. Now, indefinite storage of information relating to the experiences of 5-year-olds better have a fabulously good reason,
but
and there wasn't one.
Am I right in this, that data should not be stored longer than you use it for, than a specific use that you've clearly spelt out what you're going to use that data for?
That's called purpose limitation.
Yes.
So you must have a purpose before you collect the data. If you think to yourself, there must be something useful I can do with this later, and you collect it all for the purposes of thinking about it later, that is not a legitimate collection of personal data.
A simple example is you go into a bank, you apply for a loan, you give them the details. The details are specific to that application for what you want, so they have to ask you for certain details, you have to provide certain details. That can't live longer than the process of the application, and then more importantly, if they want to call you within 12 months relating to a similar product, they may need to have to seek other approvals from you to do so again. Consents, so you have to have signed consents, and then if the account is closed, say January this year, they can't hold on to the data for any longer than 6 years after that.
And the reason that it's 6 years is because there's a legal reason for 6 years. It's not an arbitrary figure plucked out of the sky where you just think it seems not too long but not short. It's because there's a 6-year statute of limitations in respect to civil claims.
Yeah.
And so therefore if you keep it beyond 6 years, you're not keeping it in order to meet any claim that might happen, because the possibility of meeting one of those claims is now gone.
Yeah.
Yes.
You're not keeping it for providing the service for which it was collected, because that service provision is now ended. And therefore, you're not keeping it for any purpose that it was legitimately collected. So that means wipe it.
So this leads us straight into, and this is mainly why we've asked you in today, is the public services card. Why is all of this data being funneled into the public services card? It was set up several years ago. Supposedly it's a civil service driven proposal, the public services card. It wasn't a politically driven
There's no question in my mind that this is an administrative project. That's quite clear, both because of its lifespan. Generally speaking, you can't run a political project across that number of governments over that number of years, and you need to have it to be driven from the administrative end. That's not to say that there is no political purpose or consequences from it, but certainly in terms of its impetus, that definitely seems to be an administrative push rather than a political push. And you'll see every interview with the current minister where they cite all their previous ministers who signed off on it. You actually will see interviews with previous ministers still defending the project because they stood over it when they were there. But the thing that I would say is they inherited it, and like Yes Minister, it was one of 90,000 things that flowed past their eyeballs when they were ministers, and it did appear, because it moved very incrementally, like it was just a bunch of sensible things being done one after the other that seemed to make sense. The problem is that when you actually look at the end point, which is where we are now, there doesn't appear to be a legal basis for the things they are doing. And I will say there are two ways of approaching this, and my preference is to approach it in a two-step way. One is, what is being done currently legal? Is there a legal basis for what is being done currently?
Yes.
If the answer is no, that's an answer for what we should do now immediately.
Well, there's the question. Is it legal?
Well, first of all, I don't see a legal basis. The department has provided a number of different collections of different scraps of legislation passed over the years, taken into its whole. It doesn't provide a legal basis. I don't see how it does, and those are the legal basis the department has cited. And I should say here that that's the Department of Social Protection. But in reality, the main engine of this, I think, although social protection has been the main delivery of the project because it had the greatest leverage over the greatest number of people in the state, at the same time, the actual engine of this is coming out of the Department of Public Enterprise and Reform, deeper.
Okay.
So then the next question is, if you decide, well, okay, there isn't a legal basis, but maybe it's a great idea and there should be a legal basis. That's a whole different argument.
Yeah, but if you're going to have that argument, you have to...
Yeah, let's hear it.
Yeah,
well, you have to have the debate that goes with it.
Yes. And what happened in the UK was very much the mirror of what has happened here. Because there, in the UK, under Blair originally and later on under Gordon Brown, the government said, look, we're going to bring in a national entitlements card, which will allow you to access public services. And it's to ease your access to public services. It's a national entitlements card. And generally speaking, the public and the press and the opposition at the time said, that's a national ID card. And they said, you'll have to go by way of legislation. Now, the key difference was that there they said, you're right, we will.
Yeah.
And they brought it forward as a national ID card, and they made the argument for it as a national ID card.
Yes.
And that argument failed in the sense that the people who heard that argument decided they didn't like it, and the voters voted for the other people who said that they would scrap the scheme, and the scheme was scrapped.
But we haven't had any of this discussion. We haven't had any of this
debate. If
debate.
you are in the administrative field, and you look there to the UK for your example of how do I do this, you see, first of all, let's introduce it as a national entitlements card, a public services card, to help you access public services. That's a nice thing to learn. But you also learn that if you have the public debate, you might lose and the whole scheme might fail.
Yeah.
Answer, what will I learn from that?
Don't have the public debate.
And so I think that's where we have arrived here.
But where we get, you got to think about this, and I know this is maybe a false equivalence, but I do like it in the way it works now, because when you think of the figures that they produced for, say, for example, Irish Water, where we got the statistics that said 80% of people are now paying, where the actual when the amounts of money came out, that equated to only 33% of people were actually had paid, because if 80% of people were paying, they would have taken in more money. And when they broke it down and said, well, what we meant was is we have, those on schemes, if we take them as having paid, and those who have dispensations, we take them having paid, and then the rest of those, of that 80% of others, have paid something, not all of their bills, but something. And the idea was that if you could say 80% of people would pay, well, then you'll actually people go, God, we're all doing it, so we'll all get it. You are more likely to join the herd if you think that that's the way the herd is moving.
I would say that has very little impact on people's decisions to act, but it does have a very strong impact on whether or not a story is considered news.
Yes.
In the traditional model of news.
Yes.
So one of the great things you can do if you've got a really bad news story is to announce that this is not news.
Yes.
You say this is how it's always been. Now, under the rules of news, if this is how it's always been, it's not news and you're not allowed to publish it. News is things that are new.
Yeah.
And so if you attack that sort of notion, this is news and this is out of the ordinary, then it ceases to fall within the recognised scheme of what is news.
So it's not a scandal if
it's been going on a long time, it can't be news. If we've all known about it, it can't be news. If that's what everybody's doing, well, it can't be news. Now, that's a way of attacking a news story that appears. Now, one of the interesting things was, I mean, you see this in a lot of areas. You've used Irish water, which I'm very unfamiliar with as a topic. But in the public services card, the first impulse was to hope it would go away. Second impulse was to say, this is normal and everybody's been doing it and we've been doing it for years. Third impulse was to say, this isn't news, this is only news because it then turned into news. And you couldn't avoid saying, well, okay, it's been on the stories and there's been in the journal and it's been in the Times and it's hit the front page. That kind of is what news looks like. So then you say, it's only news because it's August. And it wouldn't count as news if it was August. Now here we are, January, which admittedly isn't exactly a hot news day either. But that is but the story has rumbled. It isn't it turns out not to be a seasonal story, but rather a story about something fundamental in terms of people's experiences in the state.
Yeah. Can I ask a question here? The control of the data, is that social welfare or is that the Department of Public Expenditure? Not public expenditure.
Deeper.
Yeah.
The Department of Public Expenditure and Reform.
Yes, and Reform, yes. Who owns the data?
Now, the Department of Social Welfare and the Department of Public Expenditure and Reform will tell you that the Department of Social Welfare is the data controller for the database. Forget the cards. They're only a token. The database of information, which is called the Single Customer View Database.
I hate that word. That expression.
There you go. So the Single Customer View Database is intended to be a database which will be shared across all government departments and agencies, and the intention is that I think something like 150 different agencies and departments will have access to this data, and the central controlling repository of this will be the Department of Social Protection. And it will be the data controller. So
it owns that data.
I'm not making a declarative.
Okay.
I'm describing a intent. The description is that it's the data controller.
Yes.
And Deeper is the data processor on its behalf.
Yeah.
Because it passes the data to Deeper.
Simon, your description of the PSC, is that accurate?
Well, the description of the relationship between controller and processor, who is the controller of the data? Is it the Department of Social Protection? Who is the processor on their behalf? Is it the Department of Public Expenditure and Reform? Isn't a question that is answered by the people themselves.
So you don't know?
No. I mean, they give an answer, but that answer isn't the definitive statement on the matter. Because who a controller and processor isn't a matter for the two to decide between themselves.
Yes.
It's a question of actual fact. You look at the relationship that each one has to the data. You look and see which one of them has the greatest influence over its use, development, who drove the collection of it, who set the standards, who is the person deciding it will be done. And they kind of look like the controller.
Okay.
It's a question of fact, not a question of policy. So at the moment, I would say, although the Department of Social Protection says they are the controller, it looks to me like certainly Deeper seems to have at least joint controller status over this data, and potentially, given that it is also the primary source of policy in respect of how it will be used and reused, it does appear to me like the more that this data is used across the civil service, the more it looks like Deeper as the source of this sharing initiative is the data controller on those circumstances. But, as I say, it's a matter of fact, and so far, although I've put in a lot of FOIs, I don't have sufficient facts to answer the question definitively. But I do know that simply announcing you're the controller and announcing this source and here is the processor isn't the method of determining the question.
And I'm sure you, like me, are absolutely instilled with confidence that social welfare have never had a breach of data protection in their long history.
I know. I mean, we know that they have. We've actually seen cases in court. I don't have to make assertions about that.
Yes.
And TJ McIntyre has an excellent collection as these things come up. He has kept examples of this on his blog, IT Law in Ireland.
Okay.
And he has. TJ McIntyre is a doctor.
That's right.
Out in UCD in the law faculty. He's the chairman of Digital Rights Ireland, and he also does an awful lot of academic research in respect to this kind of thing. So he has lots and lots of examples of data breaches, both between inadvertent data breaches, information being left behind accidentally, laptops being lost, the classic laptops on trains.
Yeah.
But he also data breaches arising from people actually being
deliberate.
Being accessing data and passing them to third parties who wish to use it for commercial purposes.
So basically, the PSC is in a forum where their security is not 100% and has been proved to be not 100% over the years.
But no security is 100%.
Yeah.
It's not an interesting assertion to say that's not 100% security, because nobody has 100% security. What we actually know is not whether or not the security is 100% is what's relevant, but whether or not the way that it's collected is legal, is justified, whether it's done under consent or whether it's done under a legal basis, grace, and so on. It's the principles of data protection law, which are not new. We have a new law coming in, the GDPR, later on.
Which is really something that I wanted to mention, because you mentioned we've had breaches, we've had incidences, we've had laptops on trains, and within our current data protection, within the current legislation, we have laws, and we have the Commissioner has teeth to penalise people, has ability to strip people of the ability to hold data, has these sort of, can issue fines, can do these things. I'm not really very aware of many people who've been...
Generally speaking, if you go along to the prosecution day, and all of them will be taken on one day, in a district court generally. If you go along to the prosecution day, it happens every quarter, and they go along and they seek prosecutions of people for breaches. So this is happening.
Yeah.
The question is, who do they prosecute?
Yes.
What do they prosecute them for? And what actions do they take in respect of complaints? Are they effective regulators? Now, I will say that the effectiveness of our regulation system has been very variable over the last number of years, if you go back far enough. And some of that has been simply institutional weakness built in, not as a result of the any actions or lack of action by the regulator. For example, the Data Protection Commissioner's office was decentralised to Port Arlington.
Yes.
If you read the annual report that covered the year that happened, 100% of staff refused to move. And
okay, so there was rancour within...
No. 100% of staff refused to move, so they didn't. So the Data Protection Commissioner moved on his own and sat in an empty office.
Oh, God.
Jesus Christ.
Until they could recruit new staff who wanted to work in Port Arlington.
Yeah.
So you can imagine the level of institutional memory loss that you get when everybody leaves all at once. And I mean, he makes reference to it at the end of his annual report. He, of course, recognises this was a significant event.
Right.
In the year.
Yeah.
There was that time my entire staff left.
Just that moment. The EastEnders music started.
And even if, and he did say that didn't happen, even if it had been the case that everybody left, and when he moved to the new office there was a whole new staff ready to go, they had all been recruited from other departments and other agencies.
So you're green people coming into a very difficult...
All at once. There was no institutional memory. Now you can have as many handbooks as you like.
Yeah.
You can have as much training and so on, but you cannot replace the kind of institutional memory that a 100%.
Well, you must know how to drive a car to teach how to drive a car.
Oh, I can't drive a car, so I couldn't comment on that. But you must know how to drive a car in order to drive a car. So I mean, when you say what is the effectiveness of the regulatory system, clearly the state has not always focused on the Data Protection Commissioner as an effective regulator and given it the necessary resources and looked after it and so on.
But the Irish Data Protection Commissioner is unique in that we have the headquarters of some of the biggest multinational corporation data miners, as I would call them, in this country. He has a huge, massive remit, including Facebook.
She is a...
she has a...
She is a regulator for the largest data stores outside the United States in the world.
That's right.
And, I mean, when you talk about data protection, Ireland has a critical role globally in data protection. We have all the eggs. They put them all in our basket. And, you know, if you thought about it too long as to what that meant globally for everybody else, you would break out into a sweat at the fear that we might accidentally drop the basket.
Yeah.
We have all the data.
Have you ever, there's a little, you can go on to, you know, the Tor browser?
Yes.
So if you ever go on and there's a Tor a globe where you can look at the globe of where Tor activity originates from.
I didn't know such a thing occurred.
And it lights up the world. And you should see Ireland, folks.
Oh, I'd say so,
It is literally the centre of the universe when it comes to the traffic for that passes on what's called the dark web. And that is just purely because of we are more or less a global server room for many of these things.
Well, I mean, there are also very practical reasons as to why Ireland is a good place to put your data. It doesn't get too hot.
No, climate. Yeah.
And the primary cost of running a data center is
lower.
Is cooling the flipping chips.
Yeah.
And that's what. So if it doesn't get too hot and it's got a regular electricity supply, it rarely suffers earthquakes. We hardly ever suffer civil dissent and to smash up things and so on. So if you actually go down through the list of things you want to look at when you're looking for somewhere to put your data centers. We meet most of the physical environment requirements quite easily.
Yeah.
Our primary competitor in this is Scotland, which also meets the no earthquake, nice and cold requirement. Iceland is also a location, but it has a difficulty in respect of its transatlantic cabling. Ireland is the landing point for most of the transatlantic fibre optic cabling. One of the most significant ones was going to run London to New York, connecting the stock exchanges.
Right, yes.
And there was a little bit of an effort, a nudge was made, a suggestion was made, and it was successfully taken up that maybe Ireland might be a handy place to land that, and you could run it through Ireland.
Yeah.
And if you draw the line of that cable, which is a spectacular capacity cable, and then have a look at the planning permissions of all the recent data centres that have been announced, you'll find that it runs through Ireland and they are following that line.
Yes.
I mean, the mystery of, I wonder why there's a Apple data centre that is intended to go into Athlone is solved if you draw a line between Mayo and London. And you work.
Yes, it is actually. Now that you say it, yes, it is.
You know, life is more explicable than you might appear once you know the context in which decisions are made.
Just to pull us back to the public services card, and this was a question, and there's been a lot of discussion about this. Is it mandatory or is it compulsory?
That's an interesting question because, first of all, the fact the question is raised indicates that something has gone wrong in the implementation of any policy where you are trying to split hairs like that.
Yes.
In particular in a policy which requires the utmost level of transparency and trust if it is to be built upon by the state. If the state wishes to bring in an ID card, I don't think that's a good idea, but it could make the political argument and I could lose the political argument.
Yes.
But if the state wishes to do that, it would have to, in order to allow that to happen in a successful way, to do it with the absolute utmost transparency and clarity as to what this is and isn't for, and what it is and isn't applicable to. And what has happened, and this line, mandatory but not compulsory, is the best example of what has happened, is that we have the most garbled, inconsistent, unclear statements of what this is all about being presented, at the same time as assertions are made that it just has to go ahead.
Yeah.
We just have to go ahead even though we can't explain what the hell we're doing. You just have to get it even though we can't actually find the reason that you have to get it. You just have to.
There's a reason where I love the logic where, because this happened, I don't know, was it budget 2015 where, you know, when they passed the finance budget then a few days before, once the budget is passed they then go through the individual bills.
You've got to do the bills.
Yeah, and there was one of them, if you remember, that granted the revenue extra powers that meant that they could go into your bank account and have a look at your details, and without you being made aware, or, you know, and the answer to that was, we're doing this now, sure, if you're not up to anything, what have you got to hide?
Yeah.
And now that's always a very convenient answer to.
Well, that is an illegal answer.
Yeah, but that was the kind of...
But you see, I'm a stickler.
Yeah.
If it is the case that you have a legal purpose, show me the law. If it is the case that the purpose is stateable, and you're allowed, and you've passed a law, and that law is proportionate and necessary, because even if you pass a law, you can't just pass a law and make illegal things legal.
Yes.
And that was the key outcome of the Barra judgment. That is a judgment from the Court of Justice of the European Union. Again, it's the top court in interpreting European law. It's the definitive statement in respect of what is legal and isn't under European law in the EU. And what the Barra judgment found was the Romanian government had passed a law which allowed it to share data between the revenue and social welfare. So they had passed a law. And here in Ireland, the presumption was in government circles that if you passed a law, you could make illegal things legal. Because having a legal basis is one of the reasons ways by which you can make things legal under EU law. That's one of the things on the data protection law. But in Romania, they passed this law, and the actions were challenged, and it went off to the Court of Justice.
Yeah.
On the grounds that, was this law compatible with European law?
Right.
And any incompatibility between European law and domestic law results in the domestic law being found inoperable, because European law is supreme across all of the EU. So the question is not whether or not you've passed a legal basis, but whether the legal basis you passed is legal.
Okay.
We have a superior legal system above our domestic legal systems, which is the EU legal system. You can't pass laws that are contrary to EU law domestically and then make things that would be illegal under EU law legal. That's not how it works. Just like, county councils can't pass laws making murder legal.
Yeah.
You can't do that because we've got a superior system that has all agreed we're not actually killing people legally.
That brings me on to the next question. This is hotly debated, and you've hotly debated, and I've hotly debated it. And again, we're going to have to make the distinction between the card and the actual database. Biometric. Is this biometric data that is being collected?
Oh, I see. Again, at the very start you asked me what is data and what is personal data. And boringly, I quoted the law. Because that's the answer to the question, not what I think data is. And here, the GDPR, the General Data Protection Regulation, which, as I say, comes into force in May, has a restatement, a very clear restatement of what is biometric data. And in its restatement of what is biometric data, it specifically says, biometric data is particularly sensitive personal data. It's a special category of personal data with additional protections.
Okay.
And one of the consequences of that is sensitive personal data is data which it is illegal to process unless you manage to find some legal reason. There's a general presumption of illegality.
Yeah.
So the next question is, what is biometric data? And biometric data is anything which it says is unique to the physical characteristics of the person, such as would identify them physically, and then it gives a list of examples.
Photographs.
So, iris scans or images of people's faces
there you go.
are all biometric data, because you recognise humans by looking at a particular part of their physiognomy, and you say, there's that fella now, I recognise him. This is a particular irony for me, as I have a slight difficulty. I don't recognise faces. It takes me a long time to... I significantly don't recognise faces. I have missed my mother walking past her on the street.
Right.
And so it takes me a long time to recognise a human being. I have to see them a great deal before I'll be able to recognise them out of context. But computers have no such difficulties. And if you run an image scan over a person's photograph, a computer will recognise their face, and it's a unique identifier. And if you have collected up a bunch of facial images, you now have collected up a bunch of biometric data. That's what biometric data is.
So the PSC card
has a photograph of your face. It therefore is biometric data.
It is 100% biometric data.
I don't have to assert this. I just have to boringly read the definition of biometric data.
So you know it's biometric data.
And Sarah McInerney, who was on News Talk, was interviewing the minister, and she literally just read out the definition to the minister.
Yeah, I saw that. I heard that, actually.
And said, that's the definition of biometric data, and that's what this is. Is this biometric data? Now, the minister then wouldn't accept that it was biometric data, which is a very difficult position to deal with.
Yeah.
Because if you are dealing with people who are presenting a position, and then when they're presented with
facts,
which are, no one is arguing what is or isn't the language of the GDPR. That is passed. That is an established fact.
Mm-hmm.
So if we have a shared set of facts where we say, this is European law, and I then read you the European law, and then you say, no, I don't accept that.
Yeah.
I don't know where to go from
Well,
there.
we have we accept that we want there to be some ground rules, and the ground rules are if you're presented with empirical evidence that what you're saying is incorrect, that you accept what you're saying.
Yeah,
is
and it
incorrect.
is actually quite difficult to make a counter case. I mean, I am quite a boring person, and if I want to look at boring things, I recognise I need to try and persuade people of this, particularly if it's something they've never heard of, like data protection.
Yeah, yeah.
I need to try and persuade people that what I'm saying is accurate. And the only way I know in order to persuade people is to pile up a mound of facts and say, if you now allow me to take you through this pile of facts, I hope that you will reach the same conclusion that I have reached by the time we've shared this journey through to the other end of it. And if I take them through all the pile of facts, and yet they go, yes, I agree. These are all facts. And at the end I say, so it does look like the conclusion of that 1 + 1 is 2 generally. No, I don't accept that. I find that difficult.
Well, I think we all find that difficult.
Yeah, but you find it difficult. Emotionally you go, I don't know what to do with that. But also in addition, if you're actually in a position of trying to advance
a particular position.
Advance in a position, and the people on the other side don't accept the premise of facts as the determiner of whether you're right or wrong. It's quite difficult to then say, either I just continue to assert facts and hope that the general public are happier with that than the alternative action, or I don't.
I have a solution for you. All you get the final sentence, just on the final sentence, say, on advice of the Attorney General. This is and you get they have to accept it. Then just pretend that you have recourse to the Attorney General, and the House of Cards falls, because that seems to be the political speak for.
Well, I'm acutely conscious of the poor old Attorney General's role.
Yes.
Okay. Remember, the Attorney General is a lawyer who gives advice to clients, and the advice is to try and assist the client. That's its purpose. That they're lawyers and they help their clients. If my client comes to me and says, "Is this legal?" and I say to them, "It doesn't look very legal now," in the event that I had a client who was asking me these questions, and they said, "Is this legal?" and I said, "It's not. It doesn't really look like it is legal." Well, is there any way that it could be legal? Well, I mean, you could argue that, I then present you with an argument.
Yes.
I then present, and would that argument succeed? You'd ask me and I go, no, probably wouldn't succeed. But if you wanted to make an argument, and I think you'd probably lose, that would be an argument you could use. Now, would you then walk out the door and you say, my lawyer has told me that, and then you make the argument that I also have told you could lose? We saw in the State Papers there recently.
Yes.
There was a release under the State Papers in relation to the Kennedy and Arnold case. This is the phone tapping case from 1983, which I have a kind of
I mentioned it this week too.
And so the Kennedy and Ireland case involved tapping of phones, and was that constitutional, and was there a constitutional right to privacy?
You mentioned Kennedy and Arnold. Tell us a little bit more about that, if you wouldn't mind.
Well, it's the key case that introduced the recognition of the right to privacy in the Irish Constitution. Obviously, that's of interest to me. It also was a very large political storm. It was the famous source of the phrase "goo-boo." Oh no, I beg your pardon. You're quite wrong. That was the murders. But nonetheless, it was around the same time, and indeed, it was the thing that caused that government to fall. Goo-boo wasn't the thing that caused the government to fall. It was the question of phone tapping.
Yes.
So there were leaks coming out of the cabinet, and Sean Doherty was the Minister for Justice at the time, and Charlie Haughey was the Taoiseach, and the Department of Justice and the guards, by means unclear to date, and we'll come back to that as to why they're unclear to date, we ended up with a phone tapping of journalists to try and find out who their sources were. Of course, these days you wouldn't need to pass legislation for that purpose.
You could just,
because the metadata is available on request from the Gardaí, and you wouldn't have to tap the Gardaí to find out the sources.
Right.
However, and in those days you still had to tap phones in order to find these things out. So what was being sought was metadata. Who is your source? They didn't really care too much about the content. They wanted to know who was leaking. And as well as what was being sought, they decided, oh, well, we can't find it on one end. We can't tap all of the cabinet, but we could tap these journalists and find out who's ringing them. So that was what happened. And the journalists discovered this because the government fell, the Fianna Fáil government fell. It was replaced by a Fine Gael government, and Michael Noonan was the Minister for Justice. And Michael Noonan then came out and said, I've discovered that this is going on.
Yes.
Now, that was then the scandal broke. There was a large court case. Eventually, a number of years later, there was some... it reached the Supreme Court. It reached the High Court, I think. Actually, it reached the High Court, and there was a finding that this had been wrong, and that there was a constitutional right to privacy, and so on. Now, you were asking me about the Attorney General and the Attorney General's advice. The papers released just in the last 3 weeks, the end of the 30 year, have released also the advices that were given in respective from the Attorney General's office, what to do about having lost this case.
Yeah.
So the Attorney General received advices from the barristers in the case, and it said, well, I don't think you're going to win, but if you want to make an argument...
This is the argument.
Here's the argument to make. You can argue that it was illegal, because we're never going to win if we don't say it's illegal, but that it wasn't unconstitutional. And therefore we haven't recognised a new constitutional right to privacy.
The Attorney General at the time was George Orwell, was it?
No. The identity of the Attorney General, as always, is less important than the institution. So remember, this is the advice. So the junior counsel at the time in the case for the state, who was Michael McDougall, created a potential argument that one could argue if you wanted to take an appeal. Yeah. In the end, the Attorney General went, we're not appealing it, it's done. And if memory serves, and this is hazy memory, the Attorney General at the time was John Rogers, still an SC.
Yes.
And well, I mean, you don't stop being an SC. You don't stop being an SC. So that was the end of the case, and that was accepted as being, yes, the High Court case was the last word. But of course, if you would ask the government, what does the Attorney General say? Well, there was an available argument that the government could make and say, well, the Attorney General has given us an argument, and it's arguably X. And all of that thing is true. The thing that is left out, and which, of course, as a client, you've no obligation to reveal, is what your lawyer has told you is the chances of that argument succeeding. Yeah,
you can tell so much and stop right there.
And that's your right. And everybody has that right. I mean, I'm not saying that you shouldn't be able to do that. You should. Yeah. That's absolutely important, because otherwise you can't have people actually getting proper legal advice from their lawyers, and you'll actually find there's terrible consequences from that, though everybody thinks it would be a great idea if we did away with lawyers. There would be terrible consequences without people having the ability to access legal advice. One of the other, there's a little side issue in the Kennedy in Ireland, and as I say, some things aren't clear, and the reason things aren't clear is that this should have come to light on the 30-year rule with the release of papers.
5 years ago, am I right about this?
What would that be? 83, so that'd be 2015, so it would be released January 2016.
Yeah.
So, Madam Editor, as she was subsequently, Ms. Kennedy, in Kennedy in Ireland, decided that she would go in and have a look at the papers. After all, everyone wants to have a look at their own file.
Right.
And so these papers were released, and she went down to the National Archives, and she did a report for the Irish Times. And what she said was she was quite disappointed that there was so little available. And the reason there was so little available was that the Department of Justice hadn't given the papers to the National Archives.
Right.
Now remember, this is a law, and it is actually a crime
not to, yes.
Unless there are certain circumstances which have been followed. So one of those, and I had no idea whether those circumstances had or had not been followed. The reason given to Ms. Kennedy was that the department said they were too busy, which isn't one of the circumstances allowed under the National Archives Act. Which, by the way, due to the fact that at the time when it was being passed he was holding a number of different portfolios at once, is signed by Charlie Haughey. But the statutory instrument that sets it up. So the National Archives Act says that you may say, I'm looking for an exemption from the 30-year rule. And there are good reasons why that might be the case. Mm-hmm. So I said to myself, well, look, I mean, there's an awful lot. How are we to know whether an exemption has been obtained or not?
Yes.
So I had to look at the system by which you find an exemption.
Yeah.
And I said to myself, I cannot say right now definitively whether or not the Department of Justice has got an exemption or not. But if I could get a look at the certificates, which must be issued by the Department of Taoiseach, confirming such an exemption is permitted, then I would have a clear list of all the official secrets in the state.
And did you do this?
I did under FOI. Now, the Department of Taoiseach was kind of surprised that they're getting a request. No one had ever asked for all the list of files that weren't given out.
Yes.
Generally, they're looking for things.
Yeah.
And there was a bit of back and forth. And I will have to say, by the way, that the person in the Department of Taoiseach who dealt with this FOI was the most helpful, open, and transparent person that I have ever had dealings with under FOI, with any department. And that's not to say that all of them are terrible, but he was particularly thoughtful. Because he was willing to take a position, and when I challenged it and gave him reasons for it, he was willing to say, "Actually, I see your point,
yeah,
and I will accept that. Actually, you have found a reason by which we can release this information."
Yes.
And so he did. And so I got a whole backlog of information for going back years. I mean, it's amusing, and I did a series of blog posts on it that were very funny things. Apparently, there's a file in the Department of Foreign Affairs, a secret file that they can't reveal about Sugar.
Well, that would be interesting.
It's brilliant, isn't it? There's a file in the Department of Agriculture about secretly testing fertilizer, but oddly, it's also shared with the army.
Oh dear.
And there's also, and I found this one of the most interesting files. There's a file which was inherited in 1921 at the Institution of the State by the Dublin Metropolitan Police, and which the Gardaí continue to say cannot be released.
So they're still
From 1921?
Before. And it's the file of all informants in criminal matters.
Pre-21?
It's the names of the informants. No, since and pre.
Oh.
It's the everyone.
Yeah, no, I'm okay with that not coming out. I'm not saying anything. I hope who's listening?
I would say that I think that there is absolutely a reason why you would not reveal some of these files.
Of course, yeah.
Keeping things secret sometimes need to stay secret.
Yeah.
Although there is a moment where I have to say I feel that there must be a time when things pass into history. After all, if the file is covered by the National Archives Act, somebody decided that this was a file over which somebody should see one day.
Yes.
There cannot be a permanent secret.
There's a huge cohort of people now to cut across you who are only delighted that they think Trump next time he does something insane will just release Area 51 files to say, look, we have aliens. And there's all of these kind of... There are, like, the flat earthers are convinced Trump is going to release all of this moon landing was fake sort of stuff.
I mean, whether it's there or not, he may yet release it.
Yeah, that's probably it.
I'm going to pull us back
to... we decided, given the length and importance of this conversation, that it would be best split this podcast into two parts. This, we hope you'll agree, is the definitive guide to data protection, the PSC debacle, and the very big risks facing us in the internet age. Thanks for listening, and tune in later on again for part 2.